This video will explain your financial power of attorney. In my opinion, this is one of the most important parts of your estate plan. If you become incapacitated, there are things that go on in your everyday life that you take for granted. Paying bills, collecting payment, making sure that your taxes are done, making sure that other legal and financial decisions are made. You make these decisions all the time, but if you are unable to do those things for yourself, this is the tool that will allow somebody else to seamlessly make your decisions for you and make sure that legally and financially you are taken care of. If you don't get this part right, you've missed an opportunity for asset protection, meaning that there might not be anything left to go through your last will and testament. So the financial power of attorney is very important. When you look at the document, you'll notice that the first page says notice, and the whole notice is in all capital letters and it's bolded. That's actually required by law because this is very important, and it's the state legislature trying to get your attention and say, this is a big deal. You are giving access to another person to all of the real estate and the money that you have in your name. Even the ability to sign legal agreements or sign a deed over for property. And it is a big deal. And when you come into our office, you will sign that notice in front of a notary, indicating that you understand it's a big deal, but you need to have an incapacity plan. This is pretty crucial. When you go on to the second page, you'll notice that your name appears right at the top, and you're saying who you are and who you are naming to stand in your shoes legally. So if that person goes into a bank, the bank must deal with that person as if they're talking to you, the account holder. And hopefully you have at least one person, if not two or more people, listed as backups or alternate agents. These are the agent is the person acting on your behalf. The reason it's good to have more than one person is, well, if something happens to the person you choose as your agent, and they can't do this for you, they can't take care of your bills and so forth, then the only way to make decisions for you is guardianship court. And that's much more involved. It's expensive, mainly because if you need a higher level of care when you're incapacitated, every day is going to be expensive. And until certain arrangements can be made for you because there's no guardian, you're going to be paying a lot for care most likely in that time. So it's important to have at least one or two additional people listed as alternate agents. The whole rest of the document is what authority you are giving to the agents you have chosen. So you'll see bolded paragraph headers in the way that we drafted at Keystone Elder Law. And those bolded paragraph headers deal with all of the things you could possibly do with your money, with your real estate, signing agreements, maybe agreements for care that you need, or signing real estate documents and so forth. So it covers everything from getting your bills paid, collecting money owed to you, getting your taxes done on time, speaking to the bank. That's probably the most common use of the power of attorney. Speaking to an insurance company. That's very common as well. And we go through, you'll see all of these paragraph headers, changing the title on a vehicle at PennDOT, making sure that somebody can get into a safe deposit box, applying for benefits such as Medicaid for long-term care. Probably the most important part of this most important piece of your estate plan usually shows up at the bottom of 6 or top of page 7, depending on how we're drafting it. But it deals with the ability of your agent to make gifts on your behalf. That's extremely important because that's asset protection. That's getting money out of your name, maybe to get you eligible for Medicaid, which says you're not allowed to have much money in your name. So the goal becomes, let's make you broke on paper, but keep the money in your family so that you can get long-term care paid for. So when we have to do Medicaid planning for someone who requires a higher level of care, this language about gifting is extremely important. This is the legal authority to move large sums of money out of your name. Without that language, Pennsylvania law essentially caps how much of your money can be moved out of your name. And because of that cap, we would not be able to get you eligible for Medicaid, and you would end up spending a lot of money every single month for care that you need. So that gifting language is very important for long-term care planning and asset protection. Your financial advisor, if you work with one, or whoever might be managing your finances, might also appreciate the gifting language, because if you need to authorize the movement of money to avoid taxes or to grow your money in a way that might be using a different type of account or holding, then the financial advisor needs authority from you or your power of attorney agent to move large sums of money into a different account. So that's asset protection in the gifting language. Also, you might notice before with the gifting language, there's a number of numbered paragraphs. That's just because of the way Pennsylvania law is set up. There are certain types of authority you must specifically give, and so we go through those, some of which are duplicative of what I've already described, but some are not, such as the ability to bring a lawsuit on your behalf, the ability to maybe give up a role as a fiduciary if you're someone else's power of attorney. If you have a role in someone's trust, you need to resign from that if you're incapacitated, and you can't do it except through your power of attorney. So there's a number of different types of powers or authorities that are given there that have to be specifically mentioned. The remaining parts of the power of attorney are mostly administrative. So I get questions like, when is this effective? We write these powers of attorney to be immediately effective, meaning it might sit in a drawer, but if you're out of town and you need someone to go to the bank for you or deal with an insurance company, they can pick this up, and it doesn't matter if you are cognitively incapacitated or if you're just fine, they can pick up the power of attorney and go do that for you. But the reason we don't make it delayed and effective only when you become incapacitated is because then there's delay. That we have to have you go before a doctor or a psychologist to be examined. They have to write a report and conclude that you are in fact incapacitated. They then attach the report to this document, and only then could somebody else make decisions on your behalf. Number one, how likely do you think it is that you can be convinced by your children or somebody else that you've lost your marbles and you have to go talk to a doctor so that the power of attorney can come into effect? In my experience, people put up some resistance when that happens. So we don't want that to happen. If you truly are incapacitated, this is an immediately effective document. If you're simply out of town, if it's inconvenient, this is an immediately effective document, and it's just more seamless and avoids the expense of delay. The other question I get is, do I need to have the original to go to the bank? And the answer is no. To deal with banks, insurance companies, and so forth, a copy is almost always as good as an original. They will be able to tell that it's in the proper format under Pennsylvania law, that it has been witnessed and notarized as required by law. And you can produce a copy. In fact, you can give a copy to the bank, let them give it to their back office to check it for formality, and then your agent will be able to make decisions for you. If you have any questions about that, please let me know. But this is the power of attorney document that you will sign when you come into our office.